It is important to note Unexplained Wealth Orders, or UWOs, are an investigative tool introduced in the UK under the Criminal Finances Act in 2017. An UWO requires a respondent to explain the legitimacy of the source of funds they used to acquire property held in the UK or overseas, where there are reasonable grounds to suspect the person's known lawful income would be insufficient to buy the relevant property, and where that person is either 1. A politically exposed person or PEP, 2. Connected with a PEP, or 3. There is suspicion that they are involved in serious crime. If the respondent cannot evidence legitimate funds, the property can be frozen or seized. The new Act introduces a number of changes to make it easier for UK law enforcement to obtain UWOs. It limits the costs that enforcement authorities are required to pay as a result of a failed UWO application. This is, of course, likely to increase the use of UWOs by law enforcement, who will not be penalised where their application has failed. Law enforcement has been given more time to investigate material received in response to an unexplained wealth order before discharging any interim property freezing order over the assets in question. So I believe it's from 60 days to 186 days. For any property that is held via offshore or trust structures, UWOs can be issued to any of a corporate respondent's responsible officers, including its directors, board members, managers, and trustees. For businesses, particularly banks or firms holding assets of a respondent subject to a UWO, there may well be a considerable amount of negative reputational impact for simply being associated with the individuals concerned. In addition to this, it could even provoke further scrutiny by authorities of the firm's current due diligence practices, financial crime systems, and controls. Respondents to a UWO tend to be wealthy individuals or corporates. As properties are not always purchased in cash, it is likely they will be subject to some sort of mortgage or secured loan. Part of the income requirement test used to assess whether legitimate sources of the individual's income would have been sufficient to enable them to acquire the asset in question requires scrutinizing the mortgager, which may, as a result, inadvertently push the bank into the limelight. The authorities or regulators are likely to ask why its own due diligence procedures did not pick up on the allegedly illicit funds. For a bank or firm, having a customer that is a respondent of a UWO does not necessarily mean that there has been a failure within the firm, either at customer onboarding or during the course of the business relationship. Because of the new Act, a firm should now actively review its association with the respondent once it becomes aware of the UWO. It also needs to be aware of any legal restrictions on moving assets that arise from any court order.